Illinois Real Estate Exam Ethics Questions. Question 1. A sponsored licensee uses the team name Prairie Realty Group in advertising. Which compliance concern should be checked first during Riley's Moline single-family home file review? Option A. Whether the team name and ad clearly avoid misleading consumers about the sponsoring brokerage. Option B. Whether the team can operate without a sponsoring broker. Option C. Whether the team name creates automatic title insurance. Option D. Whether the team may set commission rates with competitors. The correct answer is option A. Whether the team name and ad clearly avoid misleading consumers about the sponsoring brokerage. Team advertising must be clear enough that consumers are not misled about the brokerage relationship and sponsorship. A team does not replace the sponsoring broker, create title insurance, or justify antitrust violations. Question 2. A homeowner challenges the assessed value used for property taxes. Which concept is being examined during Avery's Quincy 2-flat building file review? Option A. Agency termination by death. Option B. The assessment and property tax valuation process. Option C. A leasehold surrender. Option D. Escrow disbursement only. The correct answer is option B. Assessment and property tax valuation process. Property tax questions often focus on assessed value, tax rates, exemptions, and appeal procedures. Agency termination, lease surrender, and escrow disbursement are separate real estate topics. Question 3. A property is worth $313,000 and has a loan balance of $66,000. Approximately how much equity does the owner have during Cameron's Waukegan condominium unit file review? Option A. $379,000. Option B. $66,000. Option C. $247,000. Option D. $250,400. The correct answer is option C. $247,000. Equity is the property's value minus debt secured by the property, so $313,000 minus $66,000 equals $247,000. The distractors add debt, report the loan balance, or use an unsupported percentage of value.
Stressed about your AccuPlacer exam? We can take AccuPlacer exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 4. A business offers to find apartments for renters in exchange for a fee. Why might Illinois licensing law be implicated during Drew's Belleville townhome file review? Option A. Rental minus finding services are always exempt regardless of activity. Option B. Only sellers can trigger licensing law. Option C. The service becomes legal if no written records are kept. Option D. Rental minus finding services can involve regulated real estate activity when performed for compensation. The correct answer is option D. Rental minus finding services can involve regulated real estate activity when performed for compensation. Rental minus finding and leasing minus related services may be regulated when performed for compensation. The activity is not automatically exempt. Licensing law is not limited to sales, and failing to keep records does not cure an unlicensed activity issue. Question 5. A brokerage wants to operate a virtual office location for Illinois consumers. Which compliance focus best fits the licensing outline during Hayden's Chicago small apartment building file review? Option A. Registration, supervision, and public minus facing brokerage compliance for virtual or branch operations. Option B. Avoiding all broker supervision because the office is online. Option C. Replacing written brokerage agreements with website clicks only. Option D. Advertising as an unlicensed technology company. The correct answer is option A. Registration, supervision, and public minus facing brokerage compliance for virtual or branch operations. Virtual or branch operations still require appropriate brokerage supervision and compliance with licensing rules. Being online does not remove supervision, written minus agreement, licensing, or advertising requirements. Question 6. A buyer purchases for $275,000, makes a 30% down payment, and has $5,400 in closing costs. About how much cash is needed at closing before credits during Parker's Springfield mixed minus use storefront file review. Option A, $82,500. Option B, $87,900. Option C, $5,400. Option D, $269,600. The correct answer is option B, $87,900. Cash needed combines the down payment and closing costs, 30% of $275,000 plus $5,400 equals $87,900. The other choices omit either the costs or the down payment, or subtract costs from the price incorrectly. Question 7. A consumer asks why a state real estate recovery fund might exist. Which purpose is closest during Reese's Peoria vacant lot file review? Option A, guaranteeing every buyer a profit on resale. Option B, paying all ordinary home repairs after closing. Option C, providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Option D, replacing the need for broker licensing. The correct answer is option C, providing a limited source of recovery for certain losses caused by licensee misconduct when statutory requirements are met. Recovery funds are designed as limited consumer minus protection remedies for qualifying misconduct minus related losses. They do not guarantee investment profit, pay routine repairs, or replace licensing and discipline systems. Question 8. A buyer transfers contractual rights to another purchaser before closing, subject to the contract terms. Which concept is most likely being tested during Alex's Naperville rental duplex file review? Option A, accession. Option B, this cheat. Option C, hypothecation. Option D, assignment. The correct answer is option D, assignment. Assignment involves transferring contract rights to another party when permitted. Accession concerns additions to property. Escheat transfers property to the state when no heirs exist, and hypothecation involves pledging property as security without giving up possession.
Are you looking for AccuPlacer exam actual questions? Visit our website pokerexams.com to access AccuPlacer exam study guide with actual questions and answers. Scan the QR code or click the link in the description to get AccuPlacer exam answer key today.
Question 9. A rental property has NOI of $25,000 and a value estimate of $310,000. Approximately what capitalization rate is indicated during Blair's Rockford Lakefront Cottage file review? Option A, 8.1%. Option B, 4%. Option C, 11.1%. Option D, 12.4%. The correct answer is option A, 8.1%. The capitalization rate is NOI divided by value, so $25,000 divided by $310,000 is about 8.1%. The other answers have the rate, add unsupported points, or invert the formula. Question 10. Taylor has completed high school and wants a first Illinois broker license after finishing coursework in Rockford. Which education path most directly satisfies the standard broker pre-minus license requirement during Quinn's Bloomington Suburban Ranch Home File Review? Option A, only a 15-hour leasing agent course. Option B, 60 hours of broker pre-minus license topics plus 15 hours of interactive applied real estate principles. Option C, 45 hours of managing broker education without broker coursework. Option D, a continuing education course completed after licensure. The correct answer is option B, 60 hours of broker pre-minus license topics plus 15 hours of interactive applied real estate principles. Illinois broker candidates in the standard path complete 75 class hours made up of 60 hours of broker topics and 15 hours of interactive applied principles. A leasing course is for residential leasing agents, managing broker education is a different license path, and continuing education applies after licensure rather than before the broker exam. Question 11. A borrower asks about a FHA loan program during financing. Why might this appear on a licensing exam during Sydney's Champagne Commercial Suite file review? Option A, government loans never involve underwriting. Option B, government loans automatically waive all closing disclosures. Option C. Government minus related loan programs have eligibility, insurance, guarantee, or property minus condition features that differ from conventional loans. Option D. Government loans transfer the seller's deed to the lender before closing. The correct answer is option C. Government minus related loan programs have eligibility, insurance, guarantee, or property minus condition features that differ from conventional loans. Government minus related financing may involve special eligibility, insurance, guarantee, or property standards. These loans still involve underwriting and disclosures, and they do not transfer the seller's deed to the lender before closing. Question 12. A buyer obtains a loan of $192,500 on a property appraised at $250,000. Approximately what is the loan minus to minus value ratio during Logan's Joliet Farm parcel file review? Option A, 23%. Option B, 87%. Option C, 62%. Option D, 77%. The correct answer is option D, 77%. Loan minus to minus value is calculated by dividing the loan amount by the appraised value, $192,500 divided by $250,000, or about 77%. The other percentages confuse equity with LTV or use an incorrect numerator or denominator. Question 13. Hayden failed one portion of the Illinois broker licensing exam several times during the eligibility period. After the fourth unsuccessful attempt, what must happen before testing again during Kendall's Aurora single-family home file review? Option A. The candidate must retake the required broker pre-license education before retesting. Option B. The candidate may immediately test an unlimited number of times. Option C. Only the national portion must be retaken without additional education. Option D. The candidate automatically receives a leasing agent license. The correct answer is option A. The candidate must retake the required broker pre-license education before retesting. Illinois exam rules allow broker candidates up to 4 attempts during the eligibility period. After a fourth failed attempt, the candidate must complete the required pre-license education again before retaking the examination. Unlimited attempts, partial automatic exemptions, and automatic licensure are not supported. Question 14. A buyer and seller sign a purchase contract with competent parties, lawful purpose, mutual assent, consideration, and a sufficient property description. Why is the contract likely enforceable during Harper's Evanston 2-flat building file review? Option A. It is enforceable only if recorded before closing. Option B. It contains the core elements generally required for a valid real estate contract. Option C. It becomes a deed immediately when signed. Option D. It is void unless the broker drafted every paragraph. The correct answer is option B. It contains the core elements generally required for a valid real estate contract. A valid contract generally requires competent parties, mutual agreement, consideration, lawful purpose, and adequate written terms for real estate. Recording is not required for contract validity. A contract is not the same as a deed, and broker drafting is not the element that makes the contract enforceable. Question 15. A borrower pays 2 discount points on a $125,000 loan. How much do the points cost during Jamie's Oak Park condominium unit file review? Option A, $1,250. Option B, $3,500. Option C, $2,500. Option D, a different result not supported by the facts. 3. The correct answer is option C, $2,500. 1 discount point equals 1% of the loan amount, so 2 points cost 2% of $125,000, or $2,500. The other figures use too few points, only 1 point, or add an unsupported amount. Question 16. Quinn negotiates the sale of another person's 2-flat building for a promised fee. Under Illinois licensing principles, why would this activity generally require a real estate license? Option A. It is allowed without a license if the property is residential. Option B. It is exempt whenever the fee is paid after closing. Option C. It requires only a notary commission instead of a real estate license. Option D. It involves brokerage activity for compensation on behalf of another person. The correct answer is option D. It involves brokerage activity for compensation on behalf of another person. Negotiating real estate transactions for another person for compensation is a core licensed brokerage activity. Residential status, delayed payment, or holding an unrelated notary commission does not remove the need for the proper real estate license. Question 17. A closing file includes a quitclaim deed. Which distinction should an exam candidate focus on when comparing deed types during Jordan's Elgin small apartment building file review? Option A. The promises or warranties the grantor makes about title can differ by deed type. Option B. All deed types provide identical title warranties. Option C. A deed is the same document as a mortgage note. Option D. A deed never needs a grantor or grantee. The correct answer is option A. The promises or warranties the grantor makes about title can differ by deed type. Different deeds can provide different levels of title assurance, depending on the grantor's warranties. A deed is not a mortgage note, and valid deed analysis involves parties such as grantor and grantee as well as delivery and acceptance. Question 18. Blair wants to pay a sponsored Illinois licensee, Alex, directly for help with a purchase. How should compensation normally be handled during Casey's normal mixed-use storefront file review? Option A. The buyer may pay the licensee directly at any time. Option B. The sponsored licensee should receive compensation through the sponsoring broker. Option C. The title company must split the fee directly with the licensee. Option D. The licensee may accept a secret bonus if the transaction closes. The correct answer is option B. The sponsored licensee should receive compensation through the sponsoring broker. A sponsored licensee is normally compensated through the sponsoring broker rather than directly by the public. Direct payment, title minus company fee splitting outside the broker relationship, and secret bonuses create licensing, disclosure, and compensation problems.
Stressed about your AccuPlacer exam? We can take AccuPlacer exam for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done.
Question 19. Two owners are comparing tenancy by the entirety with other ownership forms. Which exam skill is being tested during Morgan's Carbondale vacant lot file review? Option A. Assuming all co-owners must have identical inheritance results. Option B. Treating a tenancy as a mortgage loan. Option C. Recognizing how ownership rights, survivorship, and transferability may differ by estate or tenancy. Option D. Using the ownership form to avoid all property taxes. The correct answer is option C. Recognizing how ownership rights, survivorship, and transferability may differ by estate or tenancy. Ownership forms can differ in survivorship rights, transferability, and the interests held by each party. They are not mortgage loans, do not guarantee identical inheritance outcomes, and do not eliminate property tax obligations. Question 20. During a first substantial discussion, Alex asks Reese whether the brokerage represents the buyer, the seller, or both. Why should the relationship be clarified early during Taylor's Galesburg rental duplex file review? Option A. The relationship is irrelevant until after closing. Option B. A broker owes no duties until a deed is recorded. Option C. Agency disclosure is needed only for commercial leases. Option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. The correct answer is option D. Agency and brokerage relationships affect duties, confidentiality, and the consumer's expectations. Brokerage relationships determine duties such as disclosure, confidentiality, obedience to lawful instructions, and care. Waiting until closing, tying duties only to deed recording, or limiting disclosure concepts to commercial leases would leave the consumer without important relationship information. Question 21. Several brokerages in Decatur agree to charge the same commission rate so no firm competes on price. Which violation is most likely being tested during Riley's Moline Lakefront Cottage file review? Option A. Price fixing. Option B, valid comparative market analysis. Option C, prioration. Option D, easement by necessity. The correct answer is option A, price fixing. An agreement among competitors to set commission rates is a classic price minus fixing concern under antitrust principles. A CMA estimates value, prioration divides expenses, and an easement by necessity concerns property access rather than broker competition. Question 22. A buyer asks about a rumor says the property is haunted, but there is no physical defect or legal restriction affecting the property. Why may this be treated differently from a material defect during Avery's Quincy Suburban Ranch home file review? Option A. Every rumor must be included in the deed. Option B. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Option C. The broker must create a structural inspection report. Option D. The seller must lower the price by statute. The correct answer is option B. Stigmatizing facts usually do not have the same disclosure treatment as physical or legal defects. Stigmatized minus property issues generally differ from material physical defects or title/legal problems. Rumors do not belong in a deed, brokers do not create structural inspection reports, and statutes do not automatically set a required price reduction for a stigma. Question 23. An appraiser values a library with few comparable sales and limited rental data. Which approach may receive special attention during Cameron's Waukegan Commercial Suite file review? Option A, income approach only. Option B, gross rent multiplier only. Option C, cost approach. Option D, subdivision platting method. The correct answer is option C, cost approach. The cost approach is often useful for new or special minus purpose properties when sales and income evidence are limited. The income approach and gross rent multiplier depend heavily on rental income, while subdivision platting is not a primary appraisal approach. Question 24. A buyer is reviewing required environmental paperwork involving LEED-based paint information for pre-1978 housing. Why are these disclosures commonly tested during Drew's Belleville Farm parcel file review? Option A. They guarantee the property has no environmental condition. Option B. They replace the purchase contract entirely. Option C. They require the broker to perform engineering tests in every sale. Option D. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. The correct answer is option D. They help buyers evaluate known or potential environmental risks before becoming bound to the transaction. Environmental disclosure laws are designed to inform buyers about known or potential risks before or during the contracting process. They do not guarantee a problem-free property, replace the contract, or require brokers to perform technical engineering tests in every transaction. Question 25. A property manager receives a residential tenant's security deposit from Avery. How should the funds be treated for licensing-exam purposes during Hayden's Chicago single-family home file review? Option A. Handle the deposit as money belonging to another party and account for it properly. Option B. Spend it immediately as management profit. Option C. Treat it as the broker's personal emergency fund. Option D. Refuse to keep any written record of the deposit. The correct answer is option A. Handle the deposit as money belonging to another party and account for it properly. Security deposits are funds connected to the landlord-tenant relationship and must be handled with proper accounting and legal care. Treating them as immediate profit, personal funds, or undocumented cash would create serious compliance issues.